started. Can everyone hear me? Yeah, perfect. So good morning, everyone. Thank you for joining with us this morning. So if you haven't already, if you could go ahead and sign into the chat box with your name and tribal organization or affiliation, that would be great. So this is the Clean Water Act TAS for water quality standards session. It's a 2-hour session, but we felt like this would be a good opportunity, since it's virtual, to have, you know, to broaden our topic. So we're also going to have some topics on, sorry, hold on one second. Jason, your IM is on, open. Great. So Roberto Gutierrez from the Air Division is also able to be with us, and he'll give a little bit of a teaser for the Clean Air Act, and if you're hoping to apply for TAS, as well as we have the experts from our Office of Regional Counsel here to answer any burning legal questions that you have regarding the TAS process and things like that. So if you can just move to the next slide, Jason. Perfect. So I just felt like this would be a good, go back one. Yeah, perfect. So this would be a good opportunity to just sort of show you who's going to be talking during today's presentation. We have Roberto Gutierrez from our Air Division, and he is our air expert with TAS. Loretta Venegas and her gorgeous grandson, Jeremiah, is going to be talking about the water aspect of TAS. And then, as I mentioned, Ivan and Tom, who are from our Office of Regional Counsel, will give us a more in-depth look at the jurisdictional legal aspects of the TAS process. And then my name is Danielle Angeles, and I'm a project officer in the Water Division, and I'll be moderating the chat box. If you have any questions, please feel free to type them in there. We'll answer them after the presentation, but we'll also have the opportunity to unmute if you need to and speak up. So with that, if there's no questions, Roberto, take it away.
Great. Thank you, Danielle. Good morning, everyone. As Danielle mentioned, my name is Roberto Gutierrez, and I'm a project officer with the Air and Radiation Division. I've been working on TAS now for the last couple of years, and the Air Division and Water Division have been teaming up to process our TAS applications for consistency and make sure we kind of discuss any issues that come up. So today, they've invited me to join them in this discussion. Briefly, today we're going to go over what treatment in a similar manner as we're going to discuss what programs are eligible, and there is going to be a focus on Clean Water Act today. I'll mention a little bit about Clean Air Act for anyone who's interested in getting the ball rolling and thinking about things. If you do have more in-depth questions about Clean Air Act, come talk to us. We're happy to discuss those with you. We'll also go into the requirements to include in a TAS application, which generally vary depending on the program that you're interested. And we'll touch upon, why would a tribe want to apply for TAS? And then the second half of the presentation, our attorneys, Ivan and Tom, they're going to go into the regular TASs and take a closer look and go into more detail. So, right. So environmental laws federal environmental laws envision a form in which the federal government issues the laws and the states implement some of the programs. The tribes are sovereign nations, and so the states' rules don't apply on tribal lands. And in absence of a of tribal regulations, the federal government steps in, and we are the authority on government on tribal land. But there is a way for tribes to apply to EPA to implement some of these programs directly, and similarly to the way a state does, and that's what this concept of TAS is. And so generally, a tribe would submit an application per program. So if you're interested in implementing portions of the Clean Air Act, that would be one application with the different statutes that you're looking to cover. If it's for Clean Water Act, there's different sections within there that you would take a look at and that you would apply for. And so those are usually separate applications depending on the program that you're interested in. And so like I said, we'll talk a little bit about air today, but this presentation is mostly going to focus on the water quality standards. So let's go to the next slide. So here, just to kind of give you an idea of these, here's a chart of all of the regulatory TAS that have been approved throughout EPA. In parentheses, you have the numbers here in Region 9. And as you can see, the Clean Air Act ones, the first set are a little on the lighter side. We don't have a lot of tribes that come in and apply for Clean Air Act, regulatory Clean Air Act statutes for various reasons. We'll talk a little bit about that. And then you can see the water quality standards by numbers is the kind of most popular program with the most approvals throughout the country and here in Region 9. And this is the part where I want to emphasize, if you're thinking about TAS and you're thinking about which programs you want to apply for, especially with the Clean Air Act ones, you need a very robust program. So a lot of these are for permitting. So if you have a lot of sources, it may make sense for you, but you would also need to have a program that can handle the permitting with enforcement and all the things that come with that. So we'll get into a little more detail on that as we go through this presentation. So if we can go on to the next slide. All right, so there's also TAS for financial assistance grants. So on the right-hand side, you see there's the Clean Water Act 106, the 319, and then the Clear Act 105. So those three programs all require matching. Those TAS applications are for a broader general program, and they have their own kind of requirements. And then on the left, you have the regulatory programs that you can apply for TAS. So you have the Clean Water Act, Quality of Water Standards, certification, you have the Safe Drinking Water Act. Under that, you have the Public Water System provisions and underground injection control, the TSCA program, and then the Clean Air Act program. And so I just want to point out here, for the Clean Air Act portion of it, we are guided by the tribal authority rule that lists out the requirements that you'll need to include in an application or that you'll need for your program in order to be eligible for TAS. For certain portions of the regulatory Clean Air Act, such as designations or issuing permits, again, you need a larger program in order to issue permits. And for tribal for designations and implementation plans, there's nothing we will accept implementation plans and suggestions and designations from all tribes when we're going through the process. So you don't necessarily have to have TAS for that purpose, and you can still participate in the program. So if we go to the next slide, we'll talk briefly about the 4 main requirements that you would need for any application that gets submitted. So number 1, you have to be a federally recognized tribe, and you have to demonstrate that in your application. You have to have a governing body with substantial duties and powers over a reservation and demonstrate to that through a description of your program. Number 3, you have to show authority to regulate resources on the reservation. And so here's where it differs and is unique depending on the program that you're applying for. And so if you are doing Clean Air Act, there are certain ways of demonstrating your authority to regulate under the Clean Air Act program. If you're doing it under the Clean Water Act, there are different information that would be included in there. And then lastly, you have to be capable of carrying out an effective program under that program that you're applying for. So here's where it really kind of makes sense to think about what your goals are, what you'd like to accomplish with your TAS, and what are the statutes that you're interested in. Because there are some portions of the Clean Air Act, for example, where if you do apply for TAS and have control under that program, you may be required to actually submit a TIP, or you may actually be required to submit an implementation plan under designations. And we could get sued for not forcing that. But like I mentioned earlier, you could still present to us your designations recommendation without having TAS. So going through the process may not be the best way to participate in the program. So keep that in mind as you're going through either the Clean Air Act program or the Clean Water Act. So I'll next hand it off to Loretta, who's going to go into more details on the application with a Clean Water Act focus.
Thank you. Good morning, everyone. I'm Loretta Venegas, and I also work in the Tribal Clean Water section along with Danielle, and Jason Brush is our manager. So today I'm going to focus and give you a brief walkthrough of the application process specifically for the Clean Water Act Water Quality Standards program. So when you are starting at this step one, which is the application for the Water Quality Standards program, you already have established your environmental programs. You have your 106 and your 319. And if you have gone through that process already, the TAS, also known as FAE, Financial Assistance Eligibility, you have pretty much already kind of gone through the same application process. For the Water Quality Standards TAS, it is a little more detailed, and it requires legal documents as well. So for step one here, again, your project officer can start working with you on the application. And the application process, basically, as in the previous slide that Roberto reviewed, you have the 4 requirements, the eligibility, in order to move forward with the application. And again, you have accomplished that with your previous Clean Water Act programs. So what we would require is a formal letter from the chairperson. It can be addressed to your project officer. And then within the letter, there's also the TAS package, which should have a detailed map of the reservation boundaries and the water resources that you're including as part of your TAS. As I mentioned, the cover letter, and also there's a legal analysis letter that kind of describes, so your legal counsel can help assist in drafting this letter, which basically covers the boundaries and how the reservation has the capability of administering all the programs once you receive the TAS. And also, we review the TAS when it comes in as a draft. We meet with our attorneys to review if there's any potential gaps, if there's any information that is needed, because we want to make sure you have a good, solid application. If there is something that is missing, then we go back and forth with you and trying to fill in those gaps with the necessary information. Also, the EPA does create an administrative index that's part of the decision document, which is basically all of the information that you have provided, just to make sure that there's a record of that documentation. Next slide, please. So once we have your complete application, the next step is to move to the public process. And the public process steps is that we have the application and we have it for a 30-day comment period. We reach out to appropriate governmental entities, and these are basically the governors of the states within your reservation is located, or any federal agencies that might be nearby the reservation, let's say US Forest Service lands. Also, if there's neighboring reservations nearby, we reach out to the chairperson just to let them know that your reservation is interested in applying for TAS. And we're letting them know if they have any comments that within the 30 days they can provide that. We also place a public notice in the local newspaper for 1 day, also requesting, announcing the time period, the comment period. And more recently, I should say, we have also extended the public process to include local governments. So local governments nearby your reservations, if it's townships, cities, we're also reaching out to see if they would like to provide any comments as well. If we receive comments, then EPA is responsible for providing a response. We may reach out to you, the tribe, for assistance in providing in responding to the comments, but EPA is the one that responds to comments. Next slide, please. Step 3. So once we have already your final application, we've gone through the public process. If we had comments, again, we responded to the comments. If we didn't have any comments, we're moving forward, and we're at the decision document. So it's a legal document, and EPA is responsible for completing the document, and we work with our attorneys in the region to kind of finalize it. And if there were any comments, then we would include this response to comment document within this legal document as well. And so EPA within the region, we review it, and then we also have to send it back to our headquarters. And so there's a review team that we work in headquarters as well, which is OGC, Office of General Counsel, and then Office of International Tribal Affairs. They also review the document just to ensure everything, legally, we have crossed all our I's and dotted our T's and everything. It's correct. And then it's sent back. So there's a 30-day review period. Once we have concurrence from everyone and the document looks final, we receive that final approval, and it's sent to our regional administrator, who makes that final decision and makes the document final. So once that is approved, then the RA notifies the tribe's chairperson in writing, and we also do the presentation of a certificate. So the TAS is accomplished, and as if you were part of the opening remarks a couple of weeks back, this year we did have a record year of completing water quality standards TAS, 6 under the Clean Water Act and 1 under the Clean Air Act. So that was the records, and we have about 24 now total for our region, which is great. So we have a great team, and we're moving forward and trying to get as much as we can approved. Next slide, please. So now you have TAS. You went through the work. We have the final decision document. We presented it to the tribe, and now you have TAS. So what does that mean? What does that exactly mean if you have TAS? So under the Clean Water Act, Section 518E authorizes EPA to treat a tribe as a state for functions that manage and protect water resources within the borders of an Indian reservation. And also under Section 303, focuses on the protection of surface water. In this session, we're again just focusing on applying for TAS for the water quality sections of 303 and 401, which is basically allowing you to develop, and you're adopting your standards, and that would be the next step. The water quality standards serve as a benchmark for your tribe to use in assessing the health of the reservation waters, and over time, any impacts can be quantified and addressed if needed. Again, this is a similar, as I mentioned earlier, as going through the 106 and 319 TAS process. Next slide, please. So you, again, just going back, you have your TAS, and when you apply for TAS, you can apply for TAS under the Clean Water Act Section 303 or under the 401. So if you have TAS for Section 303, what does that exactly mean? And so you would be able to administer your water quality standards program. You would be eligible to apply for federal approval of tribal water quality standards. And remember that major conflicts between tribal standards and adjacent will be resolved by the regional administrator, and some workload issues is the triennial review. So basically, this is kind of a list. So there's responsibilities that come with the approval of the water quality standards. Once the tribe has approved standards, then every 3 years during the triennial review, the tribe must conduct a review of their standards and also go through a public comment period. Later on this afternoon, I just want to plug in that around 2:30, I believe, there's going to be a hot tips session on the development of water quality standards. So it's a more detailed information session, and that would be led by Christina Yin later this afternoon. So I recommend that you also check that session out. Next slide, please. So what does it mean to receive TAS under 401? So under 401, the tribe will be responsible for administering the Clean Water Act 401 certification program. For example, under the NPDES permits that are issued by EPA or Section 404 under the Corps, for any activity discharging into reservations water covered by the TAS, it could not be issued without a Tribal Clean Water Act Section 401. So basically, these are the responsibilities that the tribe would have in issuing a Clean Water Act Section 401 permit for any activity that is within the reservation. Next slide, please. Another question, does the TAS for Clean Water Act Section 303 give a tribe enforcement authority? No, it does not. EPA's approval would not impose any direct enforceable requirements on the party. But once approved, water quality standards can serve as a basis for actions such as effluent limits and permits, which are enforceable. So you would have your voice in permits that the tribe will be authorizing for. Next slide. Oh, and that was all, and I will hand it off now to Tom Hagler. So he's one of our attorneys that works very closely with us. Thank you.
Okay, thank you. Am I on?
Yes, you're on.
All right, thank you. Good morning. My name's Tom Hegler, and with me today is Ivan Liebman, and we're both in the Regional Counsel's office in San Francisco. Before I start, I just wanted to say hello to the people that I've worked with before. I know there are some of you there, and pleased to meet you, the ones that I have not worked with before. And thank you for making time to attend this R-Talk. We are in some very interesting times, and I know they're especially challenging for a lot of the tribes. Everyone's dealing with a pandemic, and some of the tribes are dealing with their reservations being literally on fire. So I'm thinking of you, and thank you for joining us. What we would like to do is a couple of kind of broad comments, and then we'd like to just go through a series of individual kind of like practice points that we've picked up over the years about issues that seem to come up or that are, you know, repeat offender issues, just so we can flag them for you as you think this through. A couple of disclaimers. First, I am a practitioner. I am not an expert. There are a lot of things I do not know. And I come at this from the water quality standards side primarily, not the air side and not even really the tribal side. That said, I have been doing TASs for water quality standards since the 1990s. So I do have some accumulated experience in this, and I'm going to try to share some of that with you right now. Next slide, please, Jason. So this slide looks really busy and it's legal, and don't worry about it. I'm not going to go through it all. We have it here for two reasons. One is I wanted you to have the citations to some of the major documents that you want to look at if you're thinking about doing TAS. The other is that this really does tell a story about how TAS practice has developed over the past 40 years. So I'll go through it fairly quickly and just tell you what I think was important about each of these documents or pronouncements or whatever they are. First, obviously, is the 1984 Indian policy, which mirrored a broader federal Indian policy, which established the whole concept of government-to-government relations. And that was a big deal. There was a flurry of legislative actions that came roughly the same time. So the TAS provisions in the statutes were added to the Clean Water Act in 1987, to the Safe Drinking Water Act in 1986, and the Clean Air Act, I believe, in 1990, but I'm not positive about that one. These statutory pronouncements were then followed up with by regulations that said, how are you going to actually do this? Those citations for those regulations are there on the screen. And so the 80s and 90s had a lot of activity in terms of setting the ground rules, and we thought we'd kind of turned a corner. But we did not see what I think we were expecting to see in terms of tribes coming in and asking for TAS authority. And I think there are three reasons for this, and these are my reasons, not anybody else's reasons. I think one is that the regulations, even though they had tried to make them simple, were not, and they were kind of cumbersome to work through. The second problem, I think, was that the Montana test out of the Montana case, where you had to make a showing of inherent tribal authority, that was also cumbersome, and it was a little bit unsettled as well. So the basic underlying law was a little bit unsettled as to how we're going to do this. And then the third reason, I think, frankly, is that EPA was not really prioritizing TASs, and so the resources were not there for the agency people working on them, and we took a really long time to get around to processing them. So that all kind of, the frustrations, I think, with that came to a head during the early 2000s, and I think the tribes worked with the EPA to develop the 2008 TAS strategy. Just anecdotally, I know that a lot of people at the RTOC back then were intimately involved with lobbying headquarters and saying, look, we got to do better than this. So the TAS strategy, what it does is it kind of ritualizes and formalizes how EPA is going to process a TAS and how we're going to work with the tribe to get it done. There were some timelines that are involved and that kind of thing. So that was a good start. And I think that started to break the logjam a little bit. But the Montana test, I think, still was kind of intimidating. You had to hire a lawyer to go through the whole Montana set of cases and come up with the arguments. And that was both expensive and time consuming. So I think we really did something big when we put out the reinterpretation in 2016. And Ivan's going to talk about that a little bit more because it is a big deal. And I think that the story that I think this all tells is that, yeah, I mean, there's some fits and starts here, but I think the legal and regulatory structure over this 40 years has kind of slowly but relentlessly moved in the direction of making it easier for the tribes to get water quality standards TAS. And I think what we've seen in the last 2 years, maybe mainly in response to the reinterpretation, is that we're getting more applications in and we're processing them because now we've got some deadlines and we've got authority and we've got a simplification process. And I think that's the story that we're dealing with right now. Note that I skipped over the tribal consultation policy from 2011 on the slide there. The reason I raise that is because I think it's going to start affecting more people. Region 9 especially is trying to take that seriously so that if there is something that we do that may affect a tribal interest, we're supposed to talk to the tribe. And what we're seeing is that there are both state actions and other tribal actions that affect other tribes. And that other tribe, we got to consult with them. So if you're doing a TAS and your TAS and your water quality standards and your water quality standards program may affect a nearby tribe, then we're going to consult with that tribe. And that's just another, it's another step we have to take, but we think it's a valuable one. Next slide. And I think I'm giving this over to Ivan. Yes.
Yeah, I'll take the baton here. Thank you, Tom. Like Tom, I work also in the Office of Regional Counsel, and I'm very glad to see so many folks participating in the session, and hopefully it's useful. And like Tom, I also extend my best wishes during these tough times. I know there's a lot going on there, and that hopefully everyone's staying safe. You know, if there weren't enough attorneys here, we need you know, more additional disclaimers. So I got to throw one more disclaimer in. I'm going to say the same thing that, you know, neither Tom nor I are speaking on behalf of the agency. We're sort of speaking from our perspectives clearly, but we are trying to provide useful information and analysis on some of the legal stuff. I have not been doing TAS work as long as Tom. I've been in my position right now for about 4 years. I manage the general law group, just so folks know, and all the TAS applications and legal issues do come through my office. So I get my hands on a lot of different pots, not always too much immersed, but enough to sort of understand and know the issues. So hopefully that gives you a sense of who I am and a little bit of the perspective. And so I think the next thing we're going to talk about is just, you know, what's the impetus for tribes seeking TAS? You know, why is it important? What's the difference? And, you know, I think the general message is that every tribe is in a different circumstance and situation in terms of, you know, their needs and their interest in TAS. And, you know, EPA is there to sort of work with each tribe to the extent possible to take on those responsibilities, but the way TAS works is there's not an obligation for any particular tribe to apply for TAS. It's really when a tribe is ready and feeling like that's an important step for it to take. Each reservation is obviously configured differently. In the clean water context, there may be different types of water bodies on that reservation. There may be different stressors on those. There may be an industrial source in terms of discharge, and a tribe may have an interest in establishing water quality standards. Obviously, things like natural resources and fish habitat and other things, I think, are a big impetus. And so depending on the configuration of a reservation, often it sort of helps decide whether a tribe wants to put their foot forward and move forward. The other thing to note is that we see sort of a variety of development of environmental programs across the board. I think most tribes start with Clean Water Act 106 and 319 grant programs for things like monitoring and watershed protection. And you do that for a while and you get expertise in water quality and water quality standards. And at a certain point, maybe it doesn't look so daunting anymore to do, you know, to take on the water quality standard program itself. And so we see sort of, I think, a natural progression. And so the bottom line on these really is, you know, do what makes the most sense for your particular circumstance. And we're here to work with you. And, you know, we have plenty of attorneys like Tom and other folks that can work with your legal counsel as well to sort of scope the extent of any requests and what it should look like. And so we sort of really view it as a teamwork approach. Next slide. Tom, I'll punt this back to you.
Okay, am I on? Yes. As I think about this, we probably have these a little bit out of order because we're going to get into the reinterpretation right after this slide, but I want to go through this now anyway, since it's right there. The reinterpretation basically says that Congress delegated authority to the tribe, and I think this is a quote, within the boundaries of the reservation. And so then you get immediately to the question of what is the reservation? And then you also then get into this whole distinction between a formal versus an informal reservation. The bottom line is EPA treats them exactly the same, whether it's formal or informal. But what are we talking about here? What is informal versus informal? Well, formal are reservations that were established by a treaty, by a federal statute, by an executive order. I think there may even be a case or two where it was established by a court decision, but mainly it's the treaty, federal statutes, or executive order. EPA for about 20 years or more has treated tribal trust lands that are not within a formal reservation as reservations under a certain condition. And there's some nomenclature here issues here, because I think there's some cases and some people who are using informal reservation for other purposes. They're either kind of using it to refer to ancestral lands or something broader. We have a very specific meaning. So let me be as clear as I can. If land has been taken into trust by BIA for the benefit of the tribe, it is an informal reservation, and we treat it exactly like a formal reservation for all purposes. Okay, so that's a fairly straightforward rule. There may be some wiggle room around the edges, but not much. Has to be taken into trust by BIA for the benefit of the tribe. So here's some permutations I'll give you. What happens if a tribe does not have a formal reservation, and there's a lot of them, and only has an informal reservation? Can you do a TAS? Absolutely, because like I said, we treat informal reservations the same as a formal reservation for TAS purposes, and we've done that. We've established that pretty clearly here in Region 9. Second thing, can you include land that is in your ancestral homelands, but is held in trust for the benefit of a member of another tribe? No, that's, again, going back to the definition, has to be held for the benefit of your tribe by BIA. Can you do it if the land is held in trust for a member of your tribe? Ivan and I were talking about this. I have not run into that case yet, because usually the tribe has to work that out beforehand. But I think our answer would probably be no, that you can't, that just because a member of your tribe happens to have land held in trust on their behalf by BIA, that doesn't mean that your tribe necessarily has jurisdiction over them. So that gets a little tricky. Now, what this obviously does, I think, is puts pressure on the tribe to get BIA to take in parcels into trust. And, you know, the standard fact pattern is that a tribe is kind of reassembling its ancestral lands, and it asks BIA to take them into trust. I have heard anecdotes that this can take a long time. And I've also heard that things are getting better, but I don't really actually know. And what I'd like to do right now, since we've got this wonderful Zoom process, if you know how to do chat, could you please put in the, and you know that your tribe has had an experience with BIA putting lands into trust, could you just put in how long it took, months or years or whatever, and when you got it finally done? And don't tell me who you are or anything like that. I'm just trying to get an idea, because frankly, I don't know. I've heard very long guesstimates, and I've heard very short guesstimates. Even better, and I don't know who all is here, if we have anyone here who works for BIA and knows from the metrics how long it takes to get something put into trust, stick that into the chat box. And Danielle will keep track of all this and see what kind of responses we get, because I'm incredibly curious, and I think you are too. If you're thinking about doing this and you have parcels out there that have not yet been taken into trust, how long does that add to your process if you want to include them? So let's see if we get any kind of responses on that. Okay, now back to Ivan.
Thanks, Tom. Yeah, so, I mean, just following up on that, we do sometimes get tribes that do want to add in parcels of land outside the reservation boundaries that are undergoing a fee to trust process. And, you know, unfortunately, our hands are bound by the Clean Water Act and the extent of what we can do. So typically what we have to do in those situations is approve the TAS for the area that is clearly within the authority to do that. And Tribes can always, at a later date, submit a revised TAS application or an expansion application, as we call them, to include those lands when they do go into trust. The thing I want to just talk a little bit about was this concept of the inherent sovereignty versus congressional delegation, assertion of authority, and the differences there. And just really more from a historical context in terms of the Clean Water Act and what it's done, but also just for general awareness. So without the congressional delegation, the path that we have to go through to demonstrate jurisdiction or authority really is inherent sovereignty, which is the, I think folks on this call understand it probably better than any of us, but really the inherent right of power to self-govern, first established in 1831 in one of the Marshall opinions, Cherokee Nations versus Georgia. Some of the TAS applications which do not have an express congressional delegation, such as the Safe Drinking Water Act, we still do have to do inherent sovereignty analysis. The trick is that with inherent authority, there's always an issue based upon the Montana v. US case about jurisdiction over non-members. And that's essentially, that Supreme Court ruling held that a tribe would not have jurisdiction over non-members. This one applied specifically to fee land, but there, Nevada v. Hicks and some other cases also talk about non-members that don't necessarily refer to fee land. So, you know, out of safety, we just typically look at it from a non-member standpoint. And the general rule is that there would not be an authority to regulate those individuals unless there was either a consensual relationship with the tribe or where non-members' conduct threatens or has some direct effect on the political integrity, economic security, and health or welfare of the tribe. Now, in cases like water quality, we've made that showing historically prior to the reinterpretation rule, and we've done so successfully. It's been litigated and challenged, and really water doesn't remain you know, in one spot. It flows, assuming it's either a river or a stream. It flows from point to point throughout the reservation. And clearly what happens, you know, in one isolated spot, non-member or member alike will have impacts elsewhere. And so we were able to make those showings previously and defend those. The problem is that it took a lot of time, a lot of resources. Our findings of facts on that had to go out for the part of the public comment process on jurisdiction. And it really added extra work and layers that you know, slowed down the process. And I think Tom referred to that a little bit previously. And so that was part of the nexus of why in 2016 we changed it and really came forward with the fact that really, you know, looking at the Clean Water Act language, it's not that different than the Clean Air Act language, where we've had interpreted an express delegation in the Clean Air Act for a long time. And there's some court precedents for that as well. And so that's when we published for comment and finalized the reinterpretation rule in 2016. Next slide. Thank you. So let's talk a little bit about what that interpretation is and what it means. The congressional delegation in section 518E2 of the Clean Water Act does cover all waters within the reservation, regardless of ownership. So that's kind of the big one. And as we've said, the express congressional delegation does not cover areas outside the reservation. Again, we're looking at reservations as both formal and informal. So all tribal trust lands outside any formal boundary would still be considered reservation. And I think, could you go back one slide, Jason? I think he's jumped ahead. There we go. And it's an express delegation from Congress to a tribe to administer the regulatory program over their entire reservation. Subject obviously to the eligibility requirements that we were talking about previously, that you be federally recognized, you have the capability, all of that stuff. And as we said, it covers both Clean Air Act and Clean Water Act TAS applications. But this next bullet is I think the main point and probably the most important thing to focus on. What sort of showing does a tribe need to make under this for essentially their assertion of authority? And it's really simply that they meet the TAS requirements and where their boundary is in terms of the reservation. So it really just becomes more of a line drawing exercise at that point. And what that has done is it has really made issuing these TASs and getting them processed in a way that makes sense a lot more efficient and a lot quicker. And going back to Loretta's point that we've had a banner year for TASs in the Clean Water Act water quality standard. I think the fact that this standard makes more sense and is an easier process to go through has really demonstrated that. Next slide. And this is the last thing I sort of want to highlight in this inherent sovereignty versus congressional delegation analysis is just highlight a little bit of the difference between the Clean Water Act and Clean Air Act. They both relate to areas within a reservation. In the Clean Air Act context, there is the language in 301 D2B, which includes the protection of resources within the exterior boundaries or other areas within the tribe's jurisdiction. Under the Tribal Authority Rule, which implements the Clean Air Act TAS requirements, and that's found at 40 CFR Part 49, the burden to look at areas outside the reservation would oftentimes be on the tribes to demonstrate if there are other areas beyond. EPA may be able to make that finding as well. Having said that, we aren't seeing a lot of applications that include areas outside of either trust land or reservation. So some of these areas have not been fully fleshed out or developed. And if tribes have interest in looking beyond reservation boundaries in terms of TAS application, that would be a situation where I think I would urge them to, or their legal counsel, to reach out to EPA and discuss the ramifications and possibilities, in terms of moving forward on that. Next slide. All right, Tom, I'm gonna send it back your way.
Okay, I think I'm on. Let's see if this is green. Yeah. What I'd like to do now is go through, it was 3, then it was 4, then it was up to 5 or 6 kind of very discrete topics that I'll introduce quickly and give you the answers where we have them, because these are things that we see come up fairly frequently. First one. So if you treat that puzzle as your reservation, defined however you want to define, either formal or informal, can you exclude some parcels from your claim of TAS? And you may have various reasons for doing that. You may have contractual obligations that you're worried about. You may have relationship obligations that you're worried about. It's totally up to you. And the answer is yes, you can. And I've done that now a couple of times in the past 5 years. It's not permanent. If you want to change your mind down the line, you can, but you do not have to. It's not an all or nothing thing. So that's one. Next page, please. Boundaries. Boundaries we could spend a whole day on, and we're not going to, because for these, if you're doing a TAS application under the reinterpretation, really the hardest part is to show here's the boundaries of the reservation. If your tribe has no issue with boundary things, that's fine. But when you do have issues, it can take forever, and it's really a land use law issue. In most cases. So, some famous examples that I have are a boundary that was defined by an 1870 document that referred to a large rock as the major cornerstone. And we had no idea what to do with it because, the rock was gone. Another kind of interesting thing I've run into is where the boundary was somewhat known, but the water body changed. It was it was a meandering river, and it would go wherever it wanted to. So we had to figure out right now, is it in or is it out? So I think I'm just going to leave my part of that one alone, but I'm going to ask Ivan to talk about a couple he had to deal with or is still dealing with, and that's where the water body itself is the boundary. You're on, Ivan.
All right. I'm not sure I'm going to have any clear-cut answers for folks, but I think we can at least screen it as one area that comes up, and that it's an area that we'd have to have further discussions. Again, the idea is to make sure that a tribe can sort of assert jurisdiction and the ability to do things like set water quality standards and water bodies that make sense and that it uses and that pertains to it. So that's always sort of our guiding principle. But there will be situations where, say, a water body is, say, a reservation boundary, and what exactly that means. Does that include that water body? Is it the upper banks of that? Is it the low water mark? What exactly is it? And I will say the beginning of that analysis always has to go back to the creation or the embodiment of the reservation. A lot of times treaties will speak to this in terms of whether or not what portions of that water body is assumed. If there's not an easy answer there, you can get into a rather arcane area of law having to do with ownership of bed and banks and this equal footing doctrine that somehow the federal government owned the bed and banks of all navigable waters, and that passed to the states, and what that means vis-a-vis a water quality standard application. I think our general MO on this one, modus operandi, is not to get into those issues. And oftentimes the answer to these can really be fleshed out through the comment period. Again, it's at the end of the day, and I think this is an important point, it's the tribe's assertion of authority that is going out for comment. It's not necessarily EPA's determination on that. And so if there's a decent argument to be made for that, and it's an assertion that makes sense, then a lot of times maybe it makes sense to just make that assertion, have that jurisdictional boundary, and put it out there for comment, because that's really the purpose of the notice to AGs and the public, is really on the jurisdictional boundaries and if there's any disputes or concerns out there. So I think that's enough said on that one. It can take up a semester in the law course, but it's one of those ones where tribes have been successful in obtaining the ability and authority to set water quality standards for navigable waters, even when they're at boundary areas. And so that's a practice that we'll continue to work with tribes on.
Okay, thank you. One last thought on boundaries, and like I said, I mean, it's going to be a case-by-case issue. If you happen to have a boundary issue for a known particular problem, one resolution to it may be to exclude that parcel from your claim of TAS and just not deal with it at all. That's going to be something that's totally up to you, and it's going to depend on the facts and circumstances. Okay, three more things. Actually, before that, I've been watching the chat boxes and about my question about BIA and how long it takes them to process. That is distressing and depressing, and I'll leave it at that. Okay, happier stuff. So a couple of special issues here. What happens if you expand your reservation? Not a problem. You would just come back in for an expanding the definition of your reservation, whether you acquired it as part of a program of reacquiring your homelands or whatever, or if you excluded something and you want to bring it back in, that's fine. You just bring it in. It's a slightly abbreviated TAS process because you've already done most of the steps, and it's really just redefining what the reservation is. So I won't say it's lightning quick, but I have done that. Two other thoughts. Oh, I'm sorry, we're one slide down. Yeah. And then two that I don't have slides for. TAS doesn't really help you with water rights. And that's explicit in the Clean Water Act in 518. It says this doesn't affect anybody's ability to get water rights under 101G. It's a blanket problem. So if you're thinking that you're going to have a stronger right to water because of TAS, that's probably not the case. And the last one is TAS for the Clean Water Act doesn't really address groundwater issues if you have groundwater contamination as an issue. And that's because the Clean Water Act itself does not really address groundwater issues. And the federal state scheme does not necessarily address that well groundwater contamination issues. It's just how the thing is set up. And there's nothing you or I can do about that. However, so just don't go into TAS thinking that we're going to be able to solve absolutely everything. You're going to be limited to the scope of the Water Quality Standards Program within the Clean Water Act. And that was what I had. Should I turn it back over to who wants to moderate some of the questions? Because I know we've gotten one question in already.
Tom, I can go through them because there are a couple I think that pertain to what you and I have been talking about.
Okay.
Rob, Roy, question is, if you have TAS and your tribe has new lands brought into trust, what's the process to update the TAS to include those new trust lands? That one actually, Loretta, you may be the best one to answer that.
Hello. Yes, I think that was just what Tom was just describing right now, that it is, you can come back in if you have TAS already, and if you want to include additional lands, it is more of a short form, and your project officer can help with that. But yes, you can come back in, include additional lands that have come into trust.
Yeah, and just to follow up on that, we do have the regulatory streamlining rulemaking. I think I want to say it was 96, but that essentially says that where you previously demonstrated aspects necessary for TAS, you don't really need to re-demonstrate those. So especially when you're talking about water quality standards, where and then you're looking at an expanded water quality standard, really the only difference is going to be maybe the capacity or the capability in terms of implementing the program in a larger geographical area, and that's not going to be much of a lift. So I think sort of following up on Loretta's point, it's really should be a streamlined application as well as a streamlined approval as well. And then we had another question from Stephen Escobar. What about tribal reservations that was terminated, they reestablished, but the reservation is no longer same as the original size? Treaty rights for waterways within the original reservation are in place, but actual land base wasn't recovered. And I think given some of the termination activities in the 60s, especially in California, there was the Rancheria Termination Act and other things. I think that's a situation actually in California that's quite common. I know, Tom, you probably have a good take on this one.
Well, I've dealt with it. What I don't know about the second part of it, when they recreated the, I think we go, well, if the gist of the question is what is the reservation at that point, I think we go with the new definition of the reservation, which has its new boundaries, rather than the one that was terminated, even though it might have been existent under a treaty. I am open to discussing that, but that's what we have done, because that's kind of how that, and there's like 4 lawsuits that basically brought back in, it was up to like 25 or 30 tribes that got disestablished improperly. Well, they all did it improperly, but sorry, that was editorializing. But those particular ones, I think what we have done, I've done 2 of them, is we used the new boundaries, not the original boundaries from the original treaty.
Yeah, the one caveat I would say to that is that I've also seen, I know in some of the Rancheria litigation, while land was not necessarily put back into trust, reservations were restored. So if that's the case where a reservation boundary is restored, even though the land isn't necessarily put back in trust, I would think that that would be an area that would be open under the congressional delegation to be included in the TAS.
Yeah, I'm sorry if I wasn't clear. Yeah, you would go to the reservation boundaries because you got to read the case. And the case I think that I'm thinking of said it's restoring the reservation. And that means you get the reservation boundaries, even though none of that was put into trust. So that's back, that is back to a formal reservation as far as I'm concerned. Is that what you're saying, Ivan?
Yeah, that was my point.
Yeah, that's okay. So I think we agree on that.
Okay, another comment from Rob. The reservation is shaped like a donut. We have a hole in the middle. We interpreted exterior boundaries as just that, exterior, but EPA interprets the donut as having two exteriors, within the donut hole being an exterior boundary as well. Any pollution released within that donut will affect the tribe's land. So why can the tribe not assert TAS over those lands in the donut hole? That's a really good question, Rob. It's one we grapple with every day. Unfortunately, the way the delegation is read is that it's just reservation land. And really the only way you get a donut hole is somehow if there was a carve out of the reservation, if it's within the exterior. So the first place to look is just making sure that was an actual congressional carve out. Sometimes if it's just a fee parcel, that's really shouldn't be considered a donut hole. That's outside the exterior boundaries. If it passes that test and it's truly quote unquote non-reservation land, that may be where we're between a rock and a hard place in terms of being able to approve that. And what some tribes have been successful in doing is say working with local jurisdictions, whether it be the regional water board or the state water board, to come up with an MOU or something that really covers that area. But I agree, it's an area that would need special focus and consideration. Tom, do you have any other thoughts on that one?
No, because I think when you get into this, you get into what I think is going to be a hot topic of tribes who have a very clear interest in lands that are not either formal or informal reservations. What do you do at that point? And I don't think the answer is nothing, but I don't think we've kind of resolved that. And I don't want to get into that on this call right now, because I do think it's going to be a hot issue over the next year or two. Sorry to be evasive on that one.
Yeah.
Give me a call.
Yeah, I was about to say, Rob, I mean, or anyone else, if you do want to follow up, you can either reach out to me or Tom, and we can sort of look at the facts a little bit and try and help as much as we can. We had another question from Ryan Marshall. If you have confirmed that tribal water standards are not needed for your tribe, but you would like to create similar documents and procedures, is there any advice or way of simplifying the tribal water quality standard process? I'm going to kick that to someone else. Tom or Loretta or Danielle, do you have thoughts on that?
Yes, it's Danielle. And as I was sort of moderating the chat box, we do have a 1:30 session with our water quality standards team who may be able to address that better, but definitely by no means is this TAS. TAS is for EPA approved standards. If you feel like the best process is just tribally approved, that is okay too. And it simplifies the process so you don't have to go through what this presentation is about. It would just be tribally approved standards. So definitely, if you're free, come to the 1:30 session and we could talk a little bit more in depth about that. We have another question. Has EPA or federal ever taken a TAS back due to not fulfilling the requirements by a tribe?
Not that I know of.
Me
Ivan?
neither. No.
Yeah, I think the answer to that is no. We've got a fairly small universe of what, 70 altogether across the country, and I don't think any of them have. I think that's correct, but I'm not. I'm fairly sure that's correct.
Yeah, I think the thing to keep in mind is what, at least under the water quality standard program, what a TAS does, right? It gets you to the point where you can submit water quality standards. You're not necessarily obliged, but it's a separate process. I think the only thing you'd be required to do really would be the 401 certification process, because that a tribe gets approved for immediately upon approval of the TAS itself. But it just seems like I'm not sure EPA would really ever go through the process of pulling back a TAS. Worst case scenario, maybe water quality standards don't get set for a while, but that would just be my sense. Tom, any thoughts on that?
Yeah, no, I think that's right. I think that's right.
I think just one thing from the programmatic aspect of it, if it's TAS or FAE for a grant program, there may be, I think, the agency, that's a last resort to pull back an FAE or TAS approval. But if a tribe does not meet the 4 criteria for running a grant program, if they were previously approved, they might not be able to get funded. I think that's a very specific sort of situation, but just trying to be transparent with that. And for the panel and for anyone in the audience that would like to answer, if the panel would maybe want to talk about some of the pros and cons for applying for TAS. I know we touched upon it a little bit during the presentation, but any pros or cons for why a tribe may apply for TAS to get EPA approved standards? I'm thinking, Roberto, if you wanted to answer, or Loretta. Or those tribes that have TAS. I think this is also an opportunity for when, if we were all in person, if I would just kind of see who in the audience has TAS approved standards and sort of their experience with getting it. Elise has put money in the chat box, although money is not necessarily associated with water quality standards. So let's be clear about that part of it.
Yeah. This is Loretta. I was just going to say that it's case by case. Each reservation is unique, and they would have their own specifics as to why they would go for TAS under the Clean Water Act for water quality standards. Sometimes if it's they're nearby water resources, surface water, and they want to have a voice in decisions in the future, that could be an example. I think it just depends.
Yeah, this is Tom. I actually, if you don't mind, I saw your question come in. I actually wrote down a couple things, so pro and cons. I think some of it is, it totally depends on what your reservation is dealing with. Yeah, if you're on a cross-boundary river or stream, you get more of a voice on the river. The upstream states have to comply when they're writing permits upstream. They're supposed to write them so that they comply with your standards. And you can use those standards to deal with specific water quality problems or development, either upstream. The 401 cert capability is especially important if you think you're going to have someone trying to put unwanted development either right next to your tribal reservation or even on your reservation. Because it's federal, if there's a federal hook there, like federal permit or license or something. So that's a specific situation, but it's a good tool. If you're concerned mainly, or your issues are mainly groundwater, then TAS probably doesn't help you because it doesn't give you a lot of power. And I may talk about this a little bit more. You will hear more about it this afternoon. But what happens if you don't have TAS? Here's what EPA will do, because if you don't have it as a tribe, EPA is the enforcing and water quality standards entity. And if you don't have your own standards, we end up using best professional judgment when we issue permits on your reservation. And that's sometimes satisfactory and it works out okay. And sometimes it's not because, again, every tribe is different and we may not be doing it to the satisfaction of where the tribe wants to go. And in that case, I'd probably suggest getting the TAS and getting your own water quality standards in place.
Roberto, did you want to answer?
Yeah, sorry, my mute button wasn't unclicking. You know, I think I mentioned a little bit earlier that if for some of the regulatory TAS, like to take on a permitting program, that's a big undertaking. So for Navajo and for Gila River, it makes sense. They have a lot more sources. They have a robust permitting program. So if you had one or two sources, it just makes more sense to allow EPA to be the permitting authority. I also mentioned with like designations and submitting a recommendation by the tribe, you don't have, in our process, you don't have to have TAS for us to accept or to look at your recommendation. The kind of flip side to if you apply for TAS for designations and you don't submit something, we could then get sued and require the tribe or the entity to submit their implementation plan. So if you're not intending to do it on a regular basis, that could be tricky. The other thing that I would mention for Clean Air Act is I've seen that a handful of tribes also have what's called affected states, so notification under Title V or PSD. And again, with those, the PSD program and the Title V program, the rules built into those permitting programs say to reach out to the local community, the tribes and the areas. So for a lot of the tribes, they are being given notice and provided an opportunity to participate in the public comment period for the Title V permit being issued nearby on state land or the PSD permit. Definitely, especially if EPA is still the permitting authority. So that's where I would say, what doesn't make sense and think about what it is you want to accomplish with your TAS. I did see that comment about the dollar signs and yeah, I do believe that for the funding allocation that we get from headquarters, they do take into account, one of the factors that they take into account is the number of tribes with TAS. So that is also something to consider.
Yes, Roberto, thank you. And Lisa, I hear you. I guess I just wanted to clarify. So there's two different forms of TAS as Roberto brought up in the beginning of this presentation. So there's FAE for 106 and 319 for continuing programs. And then there is funding for multi-purpose grants for TAS for regulatory programs. And I just want to be very clear that that program, multi-purpose, is not guaranteed like any funding source, but this is a program that, thankfully we have been able to be funded. I think this is our third year, but we did have that break between 2015 and then we didn't get it again until 2018. So I just want to make sure that's clear. And Jason just put that into the chat. So thank you so much. There's another comment from Jeff Lynch from Cortina. We currently have our water quality standards out for public comment. We ended up doing a use sustainability analysis for two drainages that very rarely have water or flow. And he mentioned that it was a pretty simple process that helped. Lisa also had another question. What power is associated for the 401 cert?
Hi, this is Jason. Can you guys hear me?
So This is Tom. So could you repeat the very last part of that question, please?
So the question was, what power is there, I guess, for 401 certification?
You mean associated with a 401 certification?
Yes. Mm-hmm.
Well, okay, there's, the tribe want to have 401 certification power. If any federal activities result in a discharge on your reservation lands or in your water bodies, you get a pretty strong power to condition it to make sure that it complies with your water quality standards. That's the tightest power that you get. And it's a pretty unfettered power, although the more recent, I think about 6 months ago, there was a regulation that came out that's already in court that kind of limits a little bit to water quality standards. But if you've got, for example, the Corps of Engineers issues a discharge permit or a fill permit on your property, on your reservation water bodies, you have an ability to condition that so that it does not create problems for you. That's the power of the 401 certification. I don't know if that's where you're going with that question or not.
Lisa, I'm not sure if we answered your question. Did you want to unmute?
This is Lisa. I'm assuming you can hear me because the little mic is getting greener and greener as I talk. I was interested because Tom mentioned that 401 had some power behind it, and I realized what I'm thinking. Here's what I'm thinking, Tom. And then maybe you can answer my question. But I also can always call you because most of the EPA folks here on this session know that I will call and talk your ear off. So be careful if you say yes, call me. What I was wondering was the 401 certification is for projects that are on reservation or near reservations that potentially affect waters under which a TAS has been authorized. But is 404 not the dredge and fill? I'm sorry, I always get them mixed up. So when you started answering, I got them mixed up again in my head.
Okay, yeah, me too, actually. So 404 is the permit that the Corps gives to people who are doing a discharge. But that action of giving the permit makes the Corps subject to getting a 401 certification. And it would be certified by the entity that has jurisdiction over where that discharge is occurring. So if it is on your reservation, then you would be the certification entity, and you could put conditions on the permit requiring them to make sure that they don't violate any of your water quality standards. If it's an adjacent jurisdiction, like let's say California is going to put something just upstream of a reservation. They're going to allow someone to put in an industrial facility right on the river, 300 yards outside of your reservation. 401 doesn't necessarily help you on that directly because you cannot certify something that's outside of your jurisdiction, where the discharge is outside of your jurisdiction. However, there is a very little used provision that I think people are starting to recognize, which is if you have, and I think of it as the bad neighbor provision. If you look at 401A2, if you see that happening, you go talk to the regional administrator, and the regional administrator of EPA can issue a notice to California if they're gonna certify a nasty project right upstream from you. And then that puts into play a whole process of having a public hearing and getting the facts on it. And then the regional administrator can impose conditions on that other jurisdiction certification. This has not been used that much. The only case I can remember was up in, I believe it's the Washington-Idaho border where they had to do that. But so you're not totally powerless under 401 to deal with a bad neighbor state. But the main thrust of 401 is for activities that occur on your reservation. Did that help? Great.
Any other questions? Please feel free to unmute. So here, this last slide is just some helpful sort of links if you would like to get more information from this presentation. I wanted to thank Roberto, Jason, Tom, Ivan, Loretta for this and everyone else for your questions. If no one has any other questions, I guess we will let you go, but we're here. If you have any questions or think of anything in the future. Anything else? Anybody? All right. Well, thank you and enjoy your lunch.
Thank you.
Thank you.